Well, on behalf of CSOX and the European Study Centre at Oxford, as well as co-sponsored School of Transnational Governance, I'd like to welcome everyone on this call, on this webinar, to our wonderfully promising session on the rule of law in the European Union. Now, I'm Kalypso Nicolaidis, chairing this webinar. I have still a foot in Oxford, very gladly, but also one at STG. And I think it's fair to say that from all sides, for all of us who are on this call, probably many of us are rule of law aficionados. And that is a bit of a paradoxical, identity, because we believe that probably the rule of law is one of the most precious invention of mankind. But in the public sphere in Europe, when you say rule of law, people are like, ooh, what does it mean? It's very technical. Is it about judges? And there's this kind of thing about the rule of law that we need to translate it to a broader public because it needs to be owned by all Europeans. And indeed, in this webinar, we're going to explore the three interrelated dimensions of our conversation about the rule of law in the European Union. And to do that, we have three wonderful speakers. And our speakers will speak to these three dimensions. We will start with Marko Kmezic, who is originally from the University of Graz in his PhD, and is a lecturer and a senior researcher there. And who studied law in Belgrade, is written extensively on the rule of law, including with Routledge, his latest book, The Rule of Law Promotion, Judiciary Reform in the Western Balkans. And indeed, Marko will be discussing EU enlargement policy in the Western Balkan, the rule of law dimension. What is this rule of law conditionality? How does it work? Why is it so important? Is it really important? Is there hypocrisy in this game? And what does it imply for the likelihood of enlargement in Western Balkan? A topic, of course, very dear to CSOX, has been for many, many years. So we will then progressively zoom out or zoom in and zoom forward in time, because this topic of enlargement and the rule of law in the Western Balkan has been with us for a long time. Now, superimpose this with the post-accession dimension. What happens when you have been conditioned, rule of law conditioned, if I can put it that way, and yet not everybody's happy on the way in which you do enforce and implement the rule of law. That is specifically here the question of Bulgaria and Romania. And to discuss this question of post-enlargement rule of law verification, we have our very own Eli Gateva, who has joined us last summer. And it was a wonderful thing, Eli, that you joined our team. I'm sorry that we've kind of crisscrossed each other a bit. And with this COVID situation, it's very hard to really welcome well in a good Mediterranean way our new colleagues. But here you are, you've come to us in Oxford from the University of Manchester and Queen Mary University, as well as York. So you've been in many different places, and at LSE, where great work there on Southeast Europe, and written extensively on these issues, including your latest monograph a few years ago on European Union enlargement conditionality, before and after. And finally, we will zoom out and of course zoom forward in time very much with my colleague, Carlos Closa. We've been colleague, Carlos Closa Montero and I, for a while in the new adventure of the School of Transnational Governance. And indeed, Carlos continues to be part-time professor at the school, as well as, having his main belonging at the Spanish National Research Council, or rather living in Spain these days. But where are we, Carlos? It's always hard to know where we are physically. And indeed, brings to the rule of law issue a very important membership in the Venice Commission on democracy through law at the Council of Europe, which has done tremendous work in this area. Of course, Carlos has been a visiting fellow and teaching in many different places, from Harvard to NYU and in the Netherlands and Groningen, and has written extensively on these issues of rule of law. This time around today, he will take us to what's really happened in the rule of law vigilance, can we put it that way, vis-a-vis all EU member states. So now we're moving away from our dear region of Southeast Europe, and we are asking, what does the EU do for rule of law, and not just Hungary and Poland, but all rule of law member state. And yes, it's fair to say that there might have been some scrutiny in the past, but for the very first time last fall, the EU Commission published rule of law reports for every single member state, something some of us had called for, including myself, almost 10 years ago, working with the Commission and the OECD, for a long, long time, that in the end, to be credible in jumping up and down to call for the enforcement of rule of law for the countries that will enter, the countries that have just entered, we need to put our gaze, rule of law gaze, in a non-discriminatory way across the EU, because not a single EU member state can abstain from being scrutinized on the rule of law. And so Carlos will take us to this domain, zooming out even more and bringing us to the very latest controversy around that. So without further ado, I now want to turn to Marko to tell us more about EU enlargement policy and rule of law in the Western Balkans. Marko, the floor is yours.
Thank you very much. I'd like to thank the organizers, obviously, for having me on this wonderful panel. And I would like to start by pointing to the obvious, that the European integration has in fact made a significant and lasting contribution to a rule-based order in Europe. However, we are all witnessing over the past decade problems with democratic pluralism and governance based on the rule of law. And these can be observed, as we will hear later in this session, throughout EU member states. But on the other hand, despite being exposed to EU rule of law promotion mechanisms within the stabilization and association process for more than already 2 decades, the respect for the rule of law in Western Balkan candidate countries has been steadily declining for over a decade as well. So these enduring problems regarding the rule of law in the Western Balkans are not new and have been noted over the years, including in the latest Freedom Houses or BTI or other democratic indexes. And they are basically manifested in increase in patronage networks and clientelism, which threaten democratic institutions in the region. And similarly, the European Commission, in its infamous 2018 communication strategy, has somewhat departed from its usual technocratic language and basically accounted the state of the rule of law in the region as that the countries show clear elements of state capture, including links with organized crime and corruption at all levels of government and administration. So the apparent, this makes me wonder, how do we capture all these diplomatic slang? And my understanding is that the apparent absence of the rule of law across Europe and in the Western Balkans is mainly observed through the creation of regime-centered legal setting, which is allowing for utter arbitrariness and sometimes even violence of the ruling elites. And this has led to a wide-ranging erosion of independent institutions and control over the judiciary and independent media, which is a feature that the Western Balkans are in fact sharing with critical number of EU member states. And in this regard, I'm very happy to hear also the following speakers, because I see that this erosion of rule of law requires in fact response both within the EU and towards future member states, whereas I'll be focusing on the latter. And the question is, does the EU has what it takes? We know that the respect for the rule of law has been spelled out as one of the EU's fundamental conditions for Western Balkans EU enlargement. But however, I would like to point out the fact that the strategy of fundamentals first employed by the European Union since 2012 and reinvigorated in 2020, in fact, does suffer on three pillars of Union's rule of law enforcement. And these, if I may, are the EU's ability to effectively answer in situations when a problem of sufficient significance is detected. Secondly, the EU's capacity to monitor and intervene at an early stage of rule of law deterioration. And finally, the lack of effective mechanism for spreading of rule of law in the Western Balkans. And if you would allow me to go into more detail, first of all, we see that the overall success of the EU's rule of law promotion in the Western Balkans depends on the clarity and fairness of the conditions that are imposed on the prospective candidate countries. And what we have seen in the past is that this procedure, in fact, suffers from various set of problems, mostly as we see that a single member state can raise the overall balance clause to prevent further opening of negotiating chapters until satisfactory progress on the rule of law is achieved. And such a setup risks repeating the apparent mistake of 2019 French veto on opening of North Macedonian and Albanian EU accession talks, and as well the apparent problems between Bulgaria and North Macedonia when it comes to opening of new accession chapters. So in an event of treaty change, reviving Article 7 of the Treaty of European Union to lower the threshold for decision making would be a preferable option and should take the form of somewhat of reversed qualified majority, while gatekeeping in steps leading up to the, and not including EU membership, would still require a higher threshold. Second, the new EU approach on chapters 23 and 24, which are dealing with the rule of law and judiciary and fundamental rights, have been introduced for the first time in the Croatian negotiating process, and they still rely on an interim benchmarking system that would assess the country's preparedness to open and to close negotiating chapters, and introduces safeguard measures, most notably the aforementioned overall balance clause, which is intended to stop negotiations on all other chapters if progress on the rule of law begins to lag behind. However, in practice, these interim benchmarks are very broad and they represent somewhat of a long-term goal, which makes their annual assessment rather superficial. And in addition, the benchmarks are not tailored to specific circumstances of the countries they target, and seem in the example of as can be seen in the example of identical benchmarks developed for the two current frontrunners in the accession process, for Serbia and Montenegro. And next, the likelihood of the effectiveness of EU rule of law efforts decreases with the number of domestic veto players that are incurring net effective power losses stemming from reforms. And we have been witnessing such prospects recently in the convictions of the former Croatian Prime Minister Ivo Sanader on corruption, and as well as former Macedonian Prime Minister Nikola Gruevski on embezzlement charges. And basically these serve as striking example of the harmful effects which EU reforms can have for established elites that are often corrupt. And in this regard, these ongoing EU rule of law efforts are state-centered, which with strong emphasis on rule of law and government institutions, in particular judiciaries. But at the same time, we see that civil society remains at best simply adjunct to the institution building process. And I see here that there exists a strong need for a more inclusive bottom-up approach to EU rule of law promotion, in which civil society actors, including constructive grassroots activists and local initiatives, would be much more empowered to play a right vis-a-vis public authority in their countries. So this would help to push for compliance of key laws, at the same time to monitor their implementation and influence norm internalization. So before, but also after eventual EU membership negotiations. And finally, while the EU has put a considerable effort into promoting the rule of law, at the same time, it has been rather unsuccessful with preventing concurrent democratic backsliding. And I see that the EU is actually wrong to believe that the rule of law can be protected on its own, as it continues to disregard other principles and values that are enshrined famously in Article 2 of the Treaty of European Union. So where I see a space for, to move ahead is actually to increase EU's leverage, so to highlight the compliance, not only on doctrinal, but also on practical point of view, where at least democracy should be equally included under EU scrutiny. And of course, I would like to wrap it up as the time limit hangs upon me. And I would like to say that in order to make sustainable progress with regard to the rule of law, the implementation of democratic laws must be ensured. And I believe that this can only be done if EU would find new allies in this endeavor. And I believe that only this would be a successful precondition for eradication of the root causes of illiberal, elite-centered political systems. So the key remains still to unlock new political dynamics that would enable to break away from the established patterns of clientelism and informal networks and strong party control over media and state institutions. In other words, these liberal structures must be strengthened in order to persistently challenge illiberal power structures and norms. And there are practical ways that would ensure that. Most of them have to do with financing. And I would be able to, or I would be pleased to discuss this more in the Q&A, and I would wrap it up here for the time being.
Thank you so much, Marko. And indeed, you already stressed that compliance has to be monitored before and after and throughout. But this was not always what's happened. And so now we turn to Eli to tell us how has that worked in the cases that you investigate, Eli. Floor is yours.
Thank you. So let me share my screen. And what I would like to do is to tell you a little bit more about, I hope that this is going to work. Excellent. So I would like to tell you more a little bit about Bulgaria and Romania's experience, because I think it's they're both very interesting case studies in terms of understanding the evolution of EU's rule of law promotion before and after accession. And I think there are important links when we look at development in EU enlargement conditionality, but also they have informed thinking about the EU rule of law framework that is now applicable to all EU member states. So just very briefly, a quick background how it all happened. So why do we have what we have in the case of Bulgaria and Romania? So this is the welcoming ceremony when the accession treaty was signed back in 2005. And I think it's important to reflect that in the case of the treaty, there was this Article 39 which used to be also known as the Super Safeguard Article, which provide for the postponement of the accession of Bulgaria and Romania. So rather than the 1st of January 2007, if the Commission evaluated that there was that both countries or either of the countries was not sufficiently prepared, their accession could have been delayed by 1 year, and rather than 2007, they could have joined in 2008. So the European Commission, and this was the latest evaluation that took place in September 2006. So the Commission postponed several times making a decision whether Bulgaria and Romania will join in 2007 and 2008 in an attempt to put more pressure on both countries. So this is the then Commissioner for Enlargement, Olli Rehn. And it's very interesting to look at the way that the cooperation and verification mechanism was outlined in his speech. So essentially, the Commission argued that there are still outstanding issues in the area of judicial reform, fight against corruption, and organized crime. And this is the reason why they have established benchmarks. And I would like to draw your attention to this sentence and find it very interesting. So the mechanism allows the Commission to help the countries to continue the reforms with vigor and to verify that the expected progress is taking place on the ground. So here there is a hint already that we're not looking only at legal reforms, but very importantly, progress on the ground. And I mean, again, this is very briefly what the benchmarks for Bulgaria and Romania. So we have 6 benchmarks in the case of Bulgaria, focusing on constitutional reforms, and then also a very important focus on the judiciary and how the judiciary should be made more accountable, more efficient. And then fight against corruption is also very important benchmarks, further measures to prevent corruption, and also a strategy to fight organized crime. So organized crime was actually only in the case of Bulgaria. In the case of Romania, we have 4 benchmarks, again, with a focus on more transparent and efficient procedure. There is a focus here with specific reference to establishing an integrity agency, building progress in terms of investigations of high-level corruptions, and also taking measure to prevent, again, corruption in particular, with a focus on the local government. So this is very basically the background to what happened. And we had the cooperation and verification, in essence, extended pre-accession monitoring to EU member states for the very first time. It was a very unprecedented step. Again, it has been used only in the case of Bulgaria and Romania. It has not been applied to Croatia. And it has been also very controversial because some Bulgarian and Romanian politicians have argued that the EU has institutionalized double standards or treated Bulgaria and Romania as second-class EU member states. When the cooperation and verification mechanism was established, it was linked to the possibility of activating one of the safeguard clauses in the accession treaty, but it has expired 3 years after EU's membership. And essentially, the aim was for mechanism to be in place for 3 years, tick the benchmarks one by one, and come 2010, the mechanism is wrapped up and both countries graduate from the mechanism. This has not happened. I would argue, to everyone's surprise, the mechanism is still very much in place, more than 14 years after Bulgaria and Romania joined the European Union. Also, both countries have been holding presidency of the Council of the EU, while also being monitored by the European Union. And just the last thing to mention how exceptional this is, the Commission has published more reports on developments in Bulgaria and Romania after they joined. So after 2007, we've had more reports than before during the pre-accession period. So I think that this is also quite remarkable. So I would argue that Bulgaria and Romania provide a very interesting case studies to explore the limits in terms of EU's rule of law promotion before, but also very much after accession. And here we can touch on a number of important questions about sustainability of reform, but also democracy promotion, whether the EU can have an impact after accession, or this can only be done before accession. So how effective, this is again also another very interesting and important question. I will very briefly reflect on it. How to measure the effectiveness of the CVM. So should we look at legal amendments, legal changes, implementation, or whether we should adopt the language that the European Commission has very much adopted to talk about a sustainable track record of reforms. And even in the case also of Bulgaria and Romania, but very much in the case of the enlargement countries, we talk about irreversibility of reforms. So if we have this all high benchmarks in both cases in Bulgaria and Romania, we will argue that the mechanism has not been effective because 14 years later, it's still very much in place. And I mean, again, very much to the dislike of Bulgarian, Romanian politicians, and I'm sure some EU politicians as well. So the mechanism has not yet fulfilled its aims. We have not seen a system change of that scale or magnitude, but it does not mean that some important steps have not been taken. So some important developments have taken place, and I will briefly refer to them. What I would like to highlight some of the key lessons that we have learned. I've tried to briefly summarize them in a number of key dimensions. So the first one, I would argue, is that the Bulgarian and Romanian's experience has highlighted the primacy of Copenhagen political criteria. And the Commission has very much looked in terms of integrating the Copenhagen political criteria very firmly, especially as Marko has mentioned in the case of EU enlargement strategy. So we have the fundamentals first, and we had the importance of chapters 23 and 24 that condition the speed of the accession negotiations. But also very much now, increasingly, there is a focus on how to monitor Copenhagen political criteria after accession. And this has also been reflected in terms of the first EU rule of law reports that the European Commission published in September 2020. So Copenhagen political criteria is not only for accession countries. This is something that needs to be closely monitored and democratic. So accession to the European Union is not a point of no return. We can see countries backsliding even when they are member states. So I think that this is one thing that the European Commission and the EU has clearly realized and integrated, especially in EU's enlargement strategy. The second very important point that I would like to touch on is how interlinked the nature of the issues that the EU is trying to deal with is. You remember I showed you in the previous slides the benchmarks which the EU established in the case of Bulgaria and Romania. So initially the plan was to tick them off one by one. So when there is a constitutional amendment introduced, we remove the benchmark. For the next year, we have less number of benchmarks. But just 1 year later, in 2008, the Commission decided that all the issues are interlinked, so they should be treated as a whole rather than a set of different recommendations. And I think that this is very important in terms of understanding how advancement or lack of advancement in rule of law might have an impact in addressing other challenging issues, such as fight against corruption. Monica Macovei, who used to be Romania's justice minister, driving important judicial reforms, has argued that you cannot tackle organized crime or high-level corruption without an effective judicial system. So I think that this is a good way to start to think of them as an interlinked and interconnected, rather than focusing only on legal developments in one particular area. But by looking at them as interlinked issues, we can get a better understanding why EU solutions are not working or particularly effective as they are. And the other thing that I would also like to note is that the CVM, as you can see, has a very limited scope. So if we are talking about systemic problems, then we need to have system change with the benchmarks that the European Commission has outlined. This is clearly not going to happen. And also in the CVM reports, in the latest sets, there is recognition that other conditions that also need to be addressed in order to resolve issues of the rule of law. and high-level corruption, such as a free media, which is very important and adds another level of accountability. But we also need to look at what is missing from EU's existing mechanisms as what is missing in the case of the CVM. I would briefly reflect on the significance of institutions, because again, this has been the template very much advocated by the European Commission. In the case of EU enlargement policy, in the case of Bulgaria and Romania, there is a strong focus on building or establishing new institutions. And there is division in the literature whether institutions matter or not. I would just take a nuanced approach and argue that institutions matter, but their impact varies. So we need to understand in what cases institutions might have provided an important step in terms of delivering reforms, and when they actually have been captured and have not produced any of the desired results on the ground. And I think Bulgaria and Romania can be used quite successfully to contrast developments, for example, in terms of integrity institutions or anti-corruption institutions, how in some cases Romania has made an important progress, while in the case of Bulgaria, there has been constant making and remodeling and introduction of new institutions without producing any meaningful impact on the ground. So institutions are important, but I would say they are not a panacea. They're important, they have an impact, but the EU needs to think about who they empower and how, and this is very much building on what Marko's mentioned, not necessarily a limited top-down approach. And I would like to finish on a slightly optimistic note by arguing that even though we talk about a number of important limitations in EU's toolbox, important lessons have been learned, and the EU can play an important role even after accession. So the EU can provide a model, it can exercise pressure, but obviously it will need to develop instruments that also have teeth. In some cases, having just a set of recommendations without introducing any way to sanction behavior or is going to not be particularly efficient. So that's why this is the optimistic or slightly optimistic way to end my presentation, and I will be happy to discuss it more, is that the EU can have an impact even after accession. Thank you.
Indeed, Eli, thank you for providing absolutely the bridge for Carlos, because you started us off by stating how there has long been frustrations in Bulgaria and Romania about so-called double standards, in institutionalizing double standards. And of course, implicitly in everything you said, there is kind of a shrug of the shoulder. Well, you know, maybe double standards are legitimate in some cases. But overall, I think that it's really fair to say that probably CVM might have been better accepted if there was a sense that some version of them happened elsewhere in existing member states. And this brings us all the way to now, where indeed you were finishing on the toolbox. So here's the EU with a new instrument in its toolbox in monitoring rule of law after accession. And Carlos is going to tell us all about it.
Okay.
Carlos, the floor is yours.
Okay, thank you. I'm going to share my screen. Can you see it now?
Yeah.
Yep. Okay, great. So, so when Ellie approached me first to speak in this seminar, she asked me to have to provide an overview of the whole toolbox of the European Union for dealing with the rule of law. And I am normally very disciplined, and this time is not an exception. So I took over subtly her command, and I'm going to try to provide an overview of the whole toolbox of the European Union, but that implies that I'm going to present a very shallow view. So I apologize, because many of you probably are very familiar and acquainted with this, and probably will be saying that I'm not really giving a lot of additional information. When I thought how to deal with that without really being boring or really saying something which is very obvious. I thought that perhaps the best way to present it will be some kind of classification. Is what I have done with this table, which it tries to portray the set of instruments that are contemplated in the toolbox. I have added a couple of them which perhaps are questionable whether are part of this toolbox or not. But here in the first column, I have listed all the possible instruments related to the toolbox, and here in the rows I have several characteristics that I would like to go through to try to untangle what is there. And the first characteristic that applies to all of them is this idea of a scope, and I have differentiated between specific and general. And this is because something that Early said, and also Kalypso picked it up, is that there has been widespread accusation coming from certain countries in Central Eastern Europe that there is a kind of double standard established. Not only in the sense, in the way in which they perceive they have been treated, but also that the kind of instruments are designed specifically for certain countries. And if you look at the whole panoply of instruments, there is an element of truth, because there are quite a few specific instruments, and they are targeting specific countries' cases rather than the general ones. And the general ones, of course, Justice Scoreboard, the annual dialogue on the rule of law, and very recently the important rule of law review cycle, the reports of the Commission about that. So there is not really a large supply of instruments that look at the situation of the rule of law in every and all member states. And that is a good basis for this claim of double standards, leaving aside the substantive component of that. Second factor that I wanted to point the attention to is the effects, whether it's a preventive and reactive instrument. And here we have a kind of equilibrium, but still there is a strong predominance of preventive mechanisms, very few of them which are reactive with an enforcement dimension, basically Article 7.2 and infringement action. Basically, these are the two existing ones in the toolbox, with the new addition, of course, of the fund conditionality recently approved in December last year. That hasn't been tested yet, so we don't know how it is going to work. Third component here, which is particularly important, and I think someone alluded to the institutional dimension, but the domestic level, the institutional dimension at the European Union level, and one common element for almost all the instruments is that they rely strongly on the Commission. And that's particularly important because the Commission is the one that can initiate most of these procedures, but it's not necessarily the one that takes the decision. So there's a kind of imbalance, and we can go into more detail in the discussion, but there's a kind of imbalance in the way institutionally those procedures are constructed. In a way, in many cases, when we are speaking about reactive enforcement mechanism, they depend on other institutions, either the Council of the European Court of Justice. That has got some kind of implications. And finally, what I consider to be very important is the mechanism that each of these instruments has associated for compliance. And here you have a huge repertoire, but basically it comes down to very few things: dialogue and peer pressure and reporting, naming and shaming, what I would call soft mechanism for enforcement, and then very few of them that has got a component for strong enforcement, rulings of the European Court of Justice, and basically what can come with the funds conditionality, with the regulation of fund conditionality. So my conclusion here is that you have mechanisms for compliance which are particularly weak and very few mechanisms for strong enforcement. I will come back to that in a moment. Now, what is my assessment? How efficient are the tools? If you remember, I divided them in preventive and reactive measures. And generally speaking, what I could say about the preventive measures is that, generally speaking, they're rather inefficient. It doesn't mean that they don't produce results. There are results there. And you have adaptations and changes, and you have cases in which political pressure may have reverted some changes, but the case of Poland, but not necessarily a change of course in the substance of backsliding. You have a component of political pressures with some implications in some changes introduced in our regulation, but not necessarily, again, a change in the backsliding trend. And of course, the council-led rule of law dialogue, which is totally useless. So in summary, all what can be considered preventive measures have not had so far an impact. there may be some expectations about how much the rule of law cycle, the reports of the Commission can play, and I am really keen on this. And as Kalypso said at the very beginning, I was from the many years ago already advocating for this kind of general mechanism for looking the whole performance of all member states. But let's see how much this can go. In certain countries, like my own country in Spain, the report, the 2020 report, has some effect, for instance, on the discussions about the transformation, the changes in the law regarding the Council of the Judiciary, and there has been an empowerment of certain domestic actors appealing to the Commission to justify a strong criticism of this new project. So there is an element of feeding in domestic debates and hence empowering actors, but not necessarily provokes a strong change. Now, what about the enforcement mechanism, more reactive? There are some interesting results related to infringement actions, and that's no doubt that the court cases have produced results regarding the cases of judges in Hungary and Poland that I probably you know a lot, so we don't need to go into that, but there is evidence of that. And this has triggered an interesting debate that has been led mainly by lawyers that put high expectations in the proposal of Kim Lane-Shepley, a wonderful proposal, systemic infringement procedure, which is basically to bundle together a number of small incidental infringements and put them together as a kind of case on the rule of law. And I have many research on how much we can go along this path, because there are first strong difficulties to construct in a theoretically sound way the notion of systemic infringement. In legal terms, the basis in the treaties can be a little bit dubious. But then the second thing which worries me is that it puts the court in a very difficult position, because by really asking the court to adjudicate on systemic violations of the rule of law, basically the court becomes a kind of super-state constitutional court. It has to intervene to adjudicate in certain cases that involve relations between judiciary and the executive. And that, in a way, it could be a legitimate endeavor, but perhaps implies a level of legitimacy that is not really now emanating from the treaty. So I'm very skeptical that the court can play this role, but perhaps you can convince me in the debate that I'm wrong in this perception. We don't know, as I said before, we don't know what to expect about the regulation on funds conditionality. There has been already some skeptical views from Logan Page, a good friend of mine, but he has been very critical with the regulation. I have some expectation. I think they can work, but it's a very specific instrument. And Ellie said before that there is a concentration of this mechanism in specific areas, and when violations happen, they have a kind of more continuous dimension. And then, of course, we have Article 7, which is totally untested and will be untested because the unanimity requirement. So the provision is basically difficult, very difficult to enact, and I don't have many expectations on that. So basically, in summary, the enforcement measures also do not display a very strong record, apart from infringement actions, which are very incidental and very specific. Now, what are the key lessons learned? This Ellie asked me to reflect also on that. I would say that each of the tools separately has not have large efficacy or efficiency at all. And the same could apply to all of them community. And the fact that we have such a large toolbox indicates that the instruments are not really working well, and we are adding new instruments on that. This is, of course, a statement can be taken as the bottle is half empty, but also could be read as a full, because there are some effects, there are some small changes, there are some cosmetic changes, and perhaps it's what we can expect of the European Union. Perhaps we cannot expect that the European Union is able to deeply change some deviations from the basic value. And why? Here, I think there are three factors that should be carefully discussed. The first is the very nature of the European Union, which is a community of law, in which implementation and compliance depends on the state's adherence to respecting the law. And that provokes a catch-22 situation. The question is, why the state that challenges rule of law will be willing to comply the law coming from the European Union, be that recommendations or ever court ruling. So it's a kind of paradox. If a state is challenging the rule of law, how we can expect that we will obey the law coming from the European Union, right? And I think that should be put under reflection because lead us to a second issue, which is last instance enforcement. The most radical instrument that the European Union has got now to enforce rule of law violations, or acting against rule of law violations, are sanctions and withholding funds. And there are two things that I would like to comment in relation to that. The first is that in theory, the theory about international sanctions is there is a strong dispute on whether sanctions are efficient or not to change behavior. This not has been conclusively addressed, and there is different positions. Some authors argue that it's possible that sanctions work, but many other authors question that sanctions can work at all. And there are cases like Iran or like Cuba that illustrate that. But second is something that I have learned in comparative research, is that mechanisms of enforcement through these instruments face certain kind of limits related to power and size considerations. If you are thinking about funds will affect specifically to those countries who are receiving the funds, but you are not in the receiving end, then you don't have this kind of mechanism here. And the power and size consideration is even more important. I learned it by looking at Mercosur. In Mercosur is one of the organizations. There are 17 organizations across the world that have similar mechanisms for protecting not exactly rule of law, but rather democracy. And Mercosur has been very active, but has been very active acting on Paraguay and Venezuela, specific cases in those two countries. And there was a huge discussion in 2015 about the case of Brazil. There was an impeachment case about against the president of Brazil in that moment, Dilma Rousseff, and there was a debate whether it was the same case as Paraguay. And at that moment, I was doing research in Mercosur on this specific mechanism, and most people, almost all of them, responded the same way. Do you expect us to act against Brazil, which is the big country in the region? Do you expect a country like Uruguay, Paraguay, or even Argentina acting against this big country? I understand that this kind of size and power consideration does not travel mechanically within the European Union, but we can do this kind of mental experiment and think, will be the same to have a country deviating from rule of law the size of Germany? Will be such an easy discussion or such an easy case as we may have with another country? And my intuitive response would be, I doubt it, right? So I think power and size considerations are particularly important. And finally, the last reason why I think that enforcement faces problems is that in the last instance we have the lack of coercion that is normally associated with enforcement. And you may think that I'm putting myself in a very radical position, right? But after having witnessed some events in Spain a few years ago, in which there was a situation of rule of law violation, it became clear that the authority of courts, the authority of central authorities, and the authority of institutions of the state could be challenged. And the last mechanism to enforce rule of law was precisely the physical coercion. So in absence of that, we may face a problem. And of course, here there's a question whether we want to move in that direction in considering the European Union. I don't say that we should move in that direction. What I am saying is that in the absence of the last instance mechanism of coercion, enforcement becomes very, very difficult, because then it relies on the two previous points, which I think have also problems. Now, as a way of conclusion, I don't want to really present a kind of summary, but I would like to pose a kind of provocation by way of a dilemma. And my question here is, how far can backsliding go within the European Union? And I make here an assumption. This is unpredictable. I make this assumption because if we think on ourselves, our thinking in around the year 2015, certain events that afterwards happened, like Brexit or like a certain president of the United States coming to power, seeming to be totally incredible, and those things happen. So my assumption is that we can we should put ourselves in a kind of a predictable situation. And in this, if this happens, the question here is a dilemma. In the absence of a mechanism to contain authoritarian reversals, suspension of membership may become the last option for protecting the rule of law of democracy within the European Union. So I'm advocating, this is my position, has been my position for many years, is perhaps that we don't have a kind of complete toolkit because there is something missing there, which is the last resource mechanism, which is suspension of membership. And I stress, we shouldn't perhaps downplay or undervalue the capacity of certain processes leading in a very negative way, even to the point to reach authoritarianism or a reversal, a total reversal of democracy. And if it's not the case, the question here should be, is the European Union prepared to retain as a member a state that has become undemocratic? So thank you very much, and I would be delighted to respond to your questions. Thank you.
Thank you very much, Carlos. And there's so much to say, and to some extent, I'd like to turn back to Marko and Eli while we are